May submit one thing.
Yes, yes.
All my friends, my lords, joined Swiss in putting on record our appreciation for lordship huge endeavor in disposing huge amount of judgment. But it's not a slip slot to orders.
Thank
It
you.
requires
Thank
a lot
you.
of application and dedication.
And there are in fact 69 matters where about 62 matters I have given dictation. But I'm not able to get time to
Fine and
read those
polishing,
things.
polishing is
So
required.
30 matter I could read, so therefore I'm pronouncing.
Okay, congratulations.
Perhaps all Tuesdays auspicious for your lordship. Last occasion 22
It is all because of you people, otherwise it's very difficult. Jointly, all of us are doing together, so therefore it is happening. The conviction and sentence order passed by the court below maintained, and the benefit of probation of offenders act granted. Item 2. The same here, the conviction and sentence maintained and probation is granted. Item 3. Here also the same thing. Probation granted, conviction and sentence maintained. Item 4. Same here, conviction and sentence maintained and probation of offenders granted. Item 5. Again the same, conviction and sentence maintained, probation granted. Item 6. Probation is granted, conviction and sentence maintained. Item 7. Period already undergone. Item 8. Conviction sentence maintained, provision of offense. Item 9. Same here, conviction maintained, sentence also maintained, provision. Item 10. In the case of 376, I have converted the sentence to the sentence already undergone and increased the compensation amount to 10,000 rupees to be paid to the victim under 357 CRPC as a compensation. Item 10. 10 is this. So that is 11. 10 is something different. I have acquitted the petitioner. This is Tapan Kumar Sahu. 397, I have acquitted. Item 12. 12 already undergone. 11. And this is again a conviction maintained and PO benefit is guaranteed. 13. Yes, conviction and sentence maintained, benefit of probation. Guaranteed. 14. Yes, 6-month probation while maintaining the conviction. 15. Period. This is an offense under section 376. I have upheld the conviction. However, the sentence I have converted to already undergone and increase the increase the fine to 10,000 rupees to be paid to the victim under 357 CRP as a compensation. 16. Probation for 1 year. 17. One-year probation. 18. Petitioner is acquitted from all the charges. 19. Petitioner is acquitted. Revision is allowed. 20. Petitioner is acquitted. 21. Two months probation. 22. The petitioner, all the petitioners are acquitted for the charges under 498-34 and section 4 of DPL. All of them are acquitted. Bail one sir. 23. Probation for 1 year while maintaining conviction and sentence. 24. One-year probation while maintaining conviction and sentence. 25. 1 year conviction, 1 year probation while maintaining conviction and sentence. 26. Probation. 1 year. 27. I have increased the fine to 20,000 rupees to be paid to the victim under 357 CRPC as a compensation. 28. Probation for 6 months while maintaining conviction and sentence. 29. One-year probation while maintaining conviction and sentence. 30. Have disposed of for the criminal MC with certain observation with the liberty. Yes.
Lord, item number 43, supplementary list.
Yes.
On the
Supplementary.
supplementary.
Okay.
On behalf of Mr. Kalyan Patnaik, his mother is expired.
43 adjourned, huh?
29 or 30, any date.
We'll give it. Yes.
Fresh admission matter, my lords. Lordship.
Very-
Very is a fact.
Very petty.
It's a
Yes.
vigilance.
Date.
Yes, next. No mentioning.
On 51, I'm praying for next week in
Huh?
a weekly list.
Weekly list. It will come, weekly list, when it comes, you tell me. It may not come. Yes. So, talk about supplementary now. Yes, let us proceed.
Item 42 be taken as first item.
First item, 42. Yes.
Item 42.
Item 42, my lords. The reason of making a prayer for to be taken off day after tomorrow, the reason, my lords, my learned friend relies a judgment of Supreme Court's, my lord, relying that particular judgment. Don't laugh. Don't laugh. Go through this
Let
one.
him complete, thereafter you
No, no. Yeah, the moment you see that it will be landing in a cleavage of judicial opinion. Lords, we turn to
Yes.
para 9, my lords.
Paranine.
I don't stand on the way for a
Reference to the-
one minute. Doge. My lords, we turn to para 9, my lords.
Yes. What do you say?
Para 9, my lords. This is that para contains the judgment on which my learned friend CBA Nendoli versus Jitendra Kumar Singh. He relies. Lords, we turn to the paragraph 11, my lords.
11.
Referring to that, the Lord's paragraph 11,
Read the
fourth
entire.
line, referring to that one, and the honorable bench of this honorable court, my lords, next page, my lords, the ratio, my lord, the sole public servant died, and under such circumstances, the appeals court concluded that the single special judge has also exercised his power under section 4(3) of the Act, and he cannot be divested of the jurisdiction to proceed against a non-public servant, even if the sole public servant stands, in as much as the charge against the public servant also awaits. Lords, you may skip all the other lines. Lords, on the last portion, the tick mark is there. The court has the considered opinion or the view that the prosecution is based on the allegation of corruption and the acquisition of disproportionate assets by the principal accused and the petitioners being the abettors, and on the death of the principal accused, the jurisdiction of the special court is not divested. The foundation of the charge is that of the petitioners abetted the principal accused who allegedly acquired and amassed disproportionate asset, and with the ill-gotten money, the properties have been acquired by them. In the said decision, the apex court held the exclusion of jurisdiction of the PC offenses has been explicitly expressed in section so and so, and ultimately, my lords, you can turn to the last para 12, my lord, para 12, the last lines, my lord. The court finds that a detailed inquiry has been made so and so, which revealed the criminal misconduct on the part of the principal accused, the former having no independent, lordship on the last page, source to begin with the business and also to become a super class contractor
In this
license.
case, charge was framed.
Yes,
Charge for it.
yes.
So I have no, the DP is told me, but this is, my lord, this is what I suggest, my lord. This is not the only one judgment, my lord. Arati Panda judgments, reported judgment is there, my lords. I'll just get all the judgment placed before lordship, so thing can be streamlined. Although there will be cleavage of judicial opinion, my lord. That's not be create further anomaly. Lordship may streamline all this matter. I will place Arati Panda judgment also, pass by another bench, my lords, or this on the courts, my lord. Lordship may day after tomorrow, I'll streamline the matters, my lords.
Take that judgment.
I understand his points, my lord.
Because this is a
and-
legal issue. If the you are only relying upon the judgment of
Yes.
Jitendra Kumar, And Jitendra Kumar is being distinguished by this court in many judgment and said that in the face of Jitendra Kumar, you can be prosecuted. Let us see.
Apart from that, the Aratiponda judgment also govern the fields, my lords.
My
So
lord.
all those things can be streamlined by the
Are
lordship.
different in.
No, I don't stand on the way of a widow.
Yes, charges has been framed, my lord.
No, in this case, charges. 173.8 is open.
He has not given me the reference.
yeah.
It says the charge
I'll
sheet has
give
been
it.
filed. See, I'll read it. I'll read it para 4. Just see, I have seen that. It says that the petitioner have been charge sheeted under section so and so and 109 so and so with the allegation that they abetted the principal accused and who is the public servant was found in possession of the asset disproportionate to his known source of income and which was further diverted to run their family business concern, namely so and so. As appears, the petitioner as well as the principal accused approached this court in so and so, seeking
No,
charge
that's-
and the common judgment so and so. Both the petitioners were disposed of with the direction for further investigation in term of 173.8. In this case, it was open.
Okay, the reference.
Ah.
Let me go.
That's the distinction.
See, I'll read that number.
That's the distinction.
I don't stand. The,
Yeah, don't know the-
Oh, see, I'm not fleeing away, sir.
You take
I'll be, it's my promise. But
after.
I don't stand on the way of a widow to face,
Yeah.
but this is the law, has to be streamlined.
My lord.
This law has to be, this is a pure question of law.
Huh.
We'll decide it.
ठीक है,
Day after.
ठीक है,
Yes.
reference है, लिखी मत दे दो उनसे लगे. You get it, the email में.
And if you, on facts, you try to distinguish.
My lords, if your lordship, we go to the law of precedents, my lords, this when Supreme Court judgment is there and
No, factually
it is
distinguishable.
not
The High Court has factually distinguished it. And whether your case is akin to Jitendra, then you get a
Definitely,
benefit.
nobody stand on the way.
Get a benefit.
On the face of Supreme Court judgment, nobody stands.
I will have to go by Supreme Court judgment only.
yeah, exactly, my lord. So
I'm
that's
not
why-
bound by the coordinate bench if there is a
My
Supreme Court
lord.
judgment
lord.
facing on the
My lord,
record.
that is what yeah. It will be per in curiam or obiter dicta, whatever.
I can't declare the parent. Why should you get into all these things? If you are covered by Supreme Court, it's all right. I
Well-
ignore all the judgments.
My lord.
Not, if a lordship, before lordship take up the other matters, my lord, this another matter, item number 33, a lordship board, but this that, to refresh a lordship, this is that laptop seizure matters, my lords.
Hmm.
Item 33, my lords. I've got the instruction regarding.
I think we are reaching.
What is suggested?
We have reached
my lord,
31.
I have to require another court. It's only my friend will pray for a passover, my lords.
Will you do it today or? you want-
I'm ready, my lords. Only if I pray for a pass.
Okay, no. Yes. 31.
31.
Yes, sir.
The appellate has been convicted of section 31D, relating to section 109 of the IPC, and he has been sentenced to arise for
Yes.
2 years and a fine of rupees 5,000.
This is a fresh matter?
Fine.
2 years sentence.
Yesterday, your lordship has admitted another CRLA of the co-appellant
Co-appellant.
by
Give the number.
CRLA number 671,
Tag कर देता है tag कर दियो
2020.
realization of fine state bail granted admit tag
I may pray one thing, when I have filed an application for stay of conviction. Let it be taken out after the.
this should be a futile attempt on your part.
He has got dismissed from the list.
Let me place my case thereafter.
I will file my objection,
Yes.
let it come 4 weeks after.
Tag with that tag give that number.
Yes, madam.
The-
Both
Application for
See-
bail has been granted.
If
Six,
bail
seven-
granted realization of whatever is possible is granted, which is not possible is not granted.
CRLA number 671 of 2024.
Yes.
It will be taxed.
Yes.
Pay for an Passover. Pay for Passover.
So conviction, it is matter.
Pass, wait, it's sentence, how much?
4 years,
We-
4 years.
4 years.
4 years, yes.
Okay,
4
4 years, same, admit, bail granted, realization of fine state, LCR called for, please. Please.
Both the matters, my appearance may be noted.
Yes, sir, of
Three
course.
copy.
You argued for him, Your name will be there.
Have your lordship.
Yes,
33. 33 pass over, my lord.
yes, pass over here, sir.
34.
34. नॉन एपीएस सर्जन दोनों साइड से कोई नहीं
35.
नहीं मैटर विल बी 34 मैटर विल बी टेकन अप टू इट इज रिटन yes yes next
35.
35
35. State has filed this CRL for cancellation of bail matter.
you have filed
State has not.
why
The noting is that notice was not sufficient.
no, what are the grounds you tell me
Three grounds are there. One is that it is 498 case. Bail was granted by the Honorable Court. That in the event of arrest, he shall be released on bail. Then three conditions were imposed by the High Court. That he has seized the dowry articles. Another is that he will not involve in other similar matter or any other offences. And
similar
he-
matter means similar
Not
offense
similar.
means he has to get married and do it once again
No.
yes
Then last one is that he's a cooperating in the investigation. He's a cooperating in the investigation. But that dowry articles was not seized. That is the actual fact. That dowry article was not seized. So the IO has given various.
personally speaking I'll tell you personally speaking I'm not speaking as a court I'm speaking as an individual the recovery of dowry articles
Right.
at the beginning of investigation is not correct.
That's correct.
Bail, they're asking for bail. Whether dowry is given or dowry is not given, that is the trial.
Yes.
And you recover it, the beginning. But this tradition is going on, recovery.
And my lord, fairly speaking that for that reason, for the informant loss, another case against the accused persons which are registered under section 506. So in that case, my lord, only notice has been issued, but I think that is not.
What I'll do is, I will allow you to move appropriate application for variation of condition if you need.
Right.
That is better idea.
There is
Right.
a sufficient ground that for cancellation of bail only.
Question of cancellation doesn't, if the trial court has granted bail, why should I cancel?
No, the Honorable High Court has.
ठीक है bail they are not acquitted bail right down the state is the petitioner in the present case petition the state is seeking cancellation of bail granted to the opposite party opposite party by this court by the order dated 16/3/2021 in ABPL number 1323 of 2020. On the ground that the condition of bail has been flouted by the opposite party. This is the case arising out of a matrimonial discord. I am not inclined to entertain this petition. However, liberty is granted to the petitioner state to move appropriate application before the court below for imposition or addition or modification of any bail condition if so required on the attending faction circumstances of the case. With this liberty, the petition.
It was filed in the 2022, whether that diary articles was seized or not in the meantime.
You never know. 21 bail is granted, 498 case. Why should you raise? With this observation, you should not go empty-handed. So I give that. Here.
36.
At least even application for cancel on the bail granted, anticipated bail, and district judge. Before this honorable court in 2017, 19 and 2020 rejected for the anticipated bail, directed the accused to go and surrender and go on bail. For 4 years they did not. Other co-accused by after my direction, surrender and went on bail. Then in 2020, she again moved the honorable court anticipated bail. You know, said same provision, observation that rejected, go to district, go to surrender and go on bail. After 4 years, the same accused filed the anticipated bail petition in the district judge, suppressing all these facts. I have prepared a small.
And in the you show me the anticipatory bail application moved by this accused before the sessions court.
Sessions
Let us
court.
see what are the disclosure he has made.
Yes, my lord.
34 para 10.
Para?
10. Here disclosure.
कौन आगे अपन की है
No, application,
No.
show me application.
The application.
Copy of application.
sir government why government is so vocal I don't know
That is page 31.
that is filed by the
Government
accused
party here, sir.
Yes.
huh.
As it disclosed, as it disclosed.
My lord is asking me to show the petition what disclosure has been done or not
I think that is 32, page 32,
my lord
if I am correct. Just check it out.
32 my lord may go to para 9 33
Yes.
here narrated all facts earlier then say para 9 after lodging FIR against the accused person 3 number of accused persons arrested and released on bail before the honorable court.
After the matter was allegedly compromised between the parties.
Thereafter, the matter alleged have been compromised between the parties. Those allegations raised by the informant already been settled. The accused number 1 to 3 complying those.
No, come to page, sir, come to para 10.
Para 10. Then, after the which is not a fact, that compromise. So, in this circumstance, at least the informant should have been given notice. So, the compromise or not, at least.
That's a different story, but disclosure he has done.
Yeah, well, yes. Then, para 10 he says, he is not disclosing about the
Earlier one.
earlier
Last one he has disclosed.
17, 19, and 2020.
Last
That
one
also,
is-
what about 20 he says?
Last petition which was dismissed by this court is 2020.
20.
He has disclosed. Before that,
No, what he has stated, the minority.
hmm.
What is stated? That the petitioner accused more further submitted before the court. He filed BLP number 1970-2020 before the High Court of Orissa, and also filed a money receipt argument 20 lakhs. That is not a fact. Due to COVID-19 pandemic, the matter has been disposed of due to state Odisha did not appear in this case. So the Honorable High Court disposed the matter. It is not a fact. I have annexed that order of this my matter to my written note. To my written note, I have annexed that order.
They what
Well, I am placing that order. 196.
190?
Para 8 of the my written note. He need not distinguish about this. I am reading that. The DL 1970-2020. What is para 10? The petition order is here now. Matter is taken up through video conference.
Your submission is there was no compromise at all.
That
He
is
has
one
missed it.
aspect. That is one aspect. Then he states about the previous bail rejected with the honorable court. He said it was government out did not appear, these are disposed of. That is not a fact. I am reading the 19th order. I am reading. That is not order. This is the third Gamya petitioner in this filing this application of court activity. Third one.
Hmm.
For the grant of bail in the event of the arrest in connection with the Nahapal case of Jantar. For a student, sit now. On the third counsel for the petitioner and learned counsel for the state. Considering the submission made and on going through the materials on record, further keeping in view this role set have been played by the petitioner, finding no change in circumstances, and not inclined to reconsider the clear grant of answer bail to the petitioner. Then it is however observed that in the event of petitioner surrenders before the land court in the session of the matter case and move these are released on bail, the same shall be considered on the own bail. Further taking into account the factor of the release of the co-accused on bail on the proper productive and dispose of the early in accordance with the law without being influenced by the order of civil in But after this on 220, she slept over the matter. Then in 2000
What is the
24.
offense you tell me?
offense, my lord. Offense you are defalcated as being 4 crores of rupees from me, from my company. 4 crores of rupees. 4 crores.
Is he a builder?
Yes, ma'am.
Who is
That
he?
is the reason. And you suppressing this fact, my lord, recent judgment of Supreme Court have held that all facts will disclose in case of Usha versus Usha Dugura versus State of Odisha, 2024 Supreme Court.
Yes, who is appearing for the
Accused. Hold on. Delibera? Written statement. File. Delibera.
She is a lady, yeah.
Again.
She is a lady, 47 years, and that to be.
All the husband, wife, all the 3 accused persons.
Apparently you have concealed the fact. 1 minute, apparently you have concealed the fact. The only thing which is in your favor is you are a lady. That is the only thing. But apparently you have concealed the fact. How much cost you will pay?
No. Well,
It is serious concealment, I tell you.
one thing, my lord.
I will not cancel the bail. Obviously, I will not cancel the bail. A court has given. But since you have concealed these facts, then heavy cost has to be imposed. And the cost will be paid to the
Informant. 4 crores rupees, my lord. 4 crores.
But 4 crores I can't recover.
And I don't say that. I don't say. Only when the game is sharp practice is doing this.
These SAR practices has to be discouraged. There is no doubt about it. So that's the reason but in the same time, bail granted by a court should not be interfered.
One question, legal question is, one is High Court has rejected bail 3 times. Can the district court grant the bail and on misconception facts? Misconception depends on facts.
There is some compromise. That's what they say.
That
The
is,
court.
that is not a ground, Lord. Not a ground. Well, at least you have called me to show whether I compromise or not. I would have said no. In the beginning, I said no compromise.
The compromise is really done. Are you ready to pay the money?
No, that no.
No, you tell me one thing. It is a matter of money dealing, basically. He is prosecuting you only to get
I am
his money
lady
back.
Well, I am a lady.
Will you pay?
I am a lady also.
Pay and finish it up. What to talk about bail? Forget about the entire case will be passed. Why do you pay? I am giving an opportunity. You settle the dispute and it can be quashed also. No problem.
Right.
And put an end to it.
Well,
Bail
2019.
is something different. But if it is a money dealing, pay and finish it up, isn't it? You can get it quashed also.
For minor information, 17 bail reject, anti-bail rejected. 18 she filed a petition to quash the proceeding and FIR.
Sir, he is already in trouble. Why are you?
I am not saying, one for minor information. He alone rejected that petition 482. Then one Supreme Court.
I
That I
I've
given
gone
it.
through your petition. So you, day after tomorrow, you come with a, you tell that if you don't pay the money and finish the matter in totality, you may have to go to the jail. You convey it so that he will come forward and pay and finish it up.
Fair enough.
And this court can cancel it also. You know that.
Fine.
And I'll send it to mediation if you agree and pay back the money and let the entire case be quashed. Day after tomorrow, come with a positive this thing. I'll send it to mediation.
Let
If
him come with the figures. what he has
figures
said.
and offer it and we'll finish it up.
Well, no problem.
That's a better idea.
Let Monday come. Next week, also, let it come next week.
Monday,
Next week, also, sir.
Monday.
Ah.
Let it
So that you
legal
get some
counsel
time.
appearing for the
Tomorrow is a holiday.
insist for cancellation of bail granted by the court below. By
Anticipated
order
bail.
dated,
It is
anticipated
anticipated
bail,
bail.
by the order dated 13/2/2024, 24 on the ground that there is a material concealment of the fact that the opposite party had repeatedly approached this court for
Anticipatory bail.
grant of concession of anticipatory bail, which has been rejected by the court
3
twice.
times. Thrice.
And the said fact was concealed. Apart from the fact that, apart from that, and besides that, the opposite party has also misled the court below, inter alia, stating that there is a compromise between the parties. Mr. Patel submits that he will persuade his client to settle the dispute, the entire dispute, and seeks an adjournment. Leave the matter on Monday. Come with a positive this thing. Otherwise, I'll cancel it. Okay.
37.
Modification of order, my lord. Only GR case has been wrongly mentioned as 205 of 2021 instead of 20. In the cause title, that is 2005 of.
You
20
might have committed a mistake anyway, so correct it. Huh? Correct. Okay, allowed. Yes.
38 requesting for a password.
Make a mention.
Yes, definitely.
The petitioner is a juvenile.
38, you are talking about 38
No, 118. May,
in supplementary.
madam. No, it's yesterday list.
Okay.
Weekly list.
Age list.
I am submitting the original certificates, serving a copy on them. Let them take instruction. This, Mr. Raghunath.
Just check it. If he's juvenile,
I'm
this is also the.
I am submitting the original certificate that then.
118 लिखो सर. 118. Where is that 118?
118.
Judicial order may pass so that.
Unnecessary. Why he will?
This was up.
What is it?
Amount comes in.
Original certificates are submitted, later on I will take it.
Yes.
Sorry, sorry.
Council, but the petitioner submits that petitioner accused.
My lord, he has been convicted in appeal confirmed, but he is juvenile.
Petitioner accused
My lord.
was a juvenile at
My
the time of commission of offence. To substantiate the same, he has placed on record
My lord.
the copies of the matriculation certificate.
Matriculation certificate, the Sanskrit and birth certificate that he.
A matriculation certificate on record, and copy of the same is supplied to Mr. Ragada. Mr. Ragada, under counsel for the state, submits that he would be seeking instruction in this regard. Leave the matter on suggestion. Awaiting the instruction. Okay. Supplementary नहीं आ सकते. Date दे दी supplementary. अब गुटे date दे दो supplementary. Let it come on supplementary. 1 week time. After 1 week, list it on the supplementary so that we'll get instruction and dispute. Okay. Yes.
Date.
38.
38, my lord, requesting for a password.
Password. Okay. Yes, Mr. Palik, you wait.
I'm in the next one, 39.
39. Yes. 39.
Wait, please, Manoj. This is
Because
that,
I give preference to the senior counsel.
I,
Senior in the age also.
we are,
You don't qualify. Sir.
since I don't qualify, Manoj, I've never taken a premium on that ever.
Yes.
My lords, this is that matter where, my lords, an FIR was lodged and I was arraigned as an accused, and that the car refinance.
Yes.
I had taken it, my
was
learned
adjourned
friends.
for what?
It keeps in.
Instruction whether the main actually I understood or not. Principal accused by that.
More-
They me to take instruction whether
No,
that.
the bank was also there, something.
Bank was
Ah.
Yes.
And whether he was arrested or not. Second thing that is.
That middleman, some Behra or some, what is his name? That middleman who is created all the problem. He has absconded, so therefore you.
Devi person of party.
Devi,
That guy is the main guy.
Main is
And you are not able to catch him, and you easy target, you have
My lord, in the meantime. yes,
gone after easy target.
And in the meantime, that petitioner has filed a motor vehicle appeal before the collector. That was perhaps dismissed. That entire I have folded my lord, the instruction.
Have you arrested or not?
He has not arrested. And my lord, there is also dispute relating that I say the loan taken by the accused persons.
no, not me, the others.
That lady, my lord. It was.
That's a all set up a different transaction.
Right.
Insofar as his transaction is concerned, it's unrelated to the crime. That's what his case is.
Correct.
He took the loan from that.
I say,
I-
Tata Finance.
Tata
I
Finance.
on-
He got it. He has no knowledge about what has happened earlier.
I have no
That's
nexus. no
a,
connection.
that is a one set of facts, and his case is one set of facts.
Entirely.
Because you are not able to ascertain the first set of facts, it doesn't mean that he
I
is
will also-
where is mens area?
My lord, if the FIR part has been stated by the informer that that Devi Prasad has sold the vehicle to the present petitioner, that is not correct.
That's
Because it was from the Suchismita Das, it was recorded in the name of Suchismita Das to whom the Devi Prasad Das had sold that vehicle. It was recorded in her name. So the FIR itself, my lord, lost by the informer. It is wrong.
But see, the problem is that that party has not changed it. He's manipulated everything in the RTO.
Yes.
My lord, that record is not available.
They are the
That
real
was-
victim in true sense.
I'm actually a victim. That's
But actually,
rightly
there
allowed.
was relating to the financial transaction by the ICICI and HDFC. That was, when I get the instruction I have folded, I was kind of for a moment. You will listen.
Why are you not arresting that man? Has he gone?
He is a absconder since that is RC was filed. He was abscond till the that I was obtaining instruction. He is absconder.
Let the IO present in the court.
For a moment, my lord, Lordship, why I have folded
Absconder,
that.
what he is a car dealer and is creating all problem. The police must be hand in glove. And again, you are merit. You are saying merit. I have heard so much.
My lord, your last officer will
That's
also
one-
directed me to take instruction.
The original RC of Innova car bearing so and so stands in the name of Devi Prasad's body is not traceable. The RTO office and from the verification of.
That is not traceable. Not traceable. That's fraud. Yeah, the बापा भी जाना तो नहीं पाएगा। हाँ, बापा भी तो warehouse है ना।
Also filed a motor vehicle appeal. What was that motor vehicle appeal? Regarding what?
My lord, I have mentioned, my lord, that folded I have that.
For transfer of that RC in my name, after I purchased,
Hmm.
transfer of the RC in my name.
That is rejected.
No, no, already transferred. It was transferred in my name and everything was, I repaid back the loan and all that. No, same appeal rejected. The others.
Who has gone? Madhusmita.
Suchi Smita. Okay. No, I had gone. I'll place 2 paragraphs. Thereafter, being agreed by this order of the registering authority, Sushant Pujari filed an appeal before the appellate authority collector, which has been disposed of with a direction dated 3/9/2010, communicated on 14/9/2010 to remit the case to the respondent RTO for a fresh hearing of the applicant and other parties. The court also set aside the impugned order. The entire exercise should be completed within a period of 1 month from the date of receipt of this order. It was further ordered that till disposal, vehicle should be kept in the custody of the person selected by the respondent, and the my lords, registration certificate of the vehicle in favor of the applicant shall not be considered as valid. After receiving the said order, the RTO Bhubaneswar had issued notice to all concerned on 16/9/2010 to make a representation, if any, on 28/9/2010 about the said vehicle and its transfer of ownership. While issuing notice to Sushant Pujari, he was further intimated to keep the said vehicle under custody of Inspector in Charge Airfield and surrender the registration certificate number so and so. The letter issued to Devi Prasanna was returned, served with the remark that the addressee left. Settavedu absconding, having committed the. On 28/9/2010, none appeared except advocate on behalf of Sushant Pujari had only prayed for time for 2 weeks and intimated the appellant is out of station, unable to take steps as per our letter. Once again, all concerned parties were informed on 19/10/2010 to make representation, if any, on 14/11/2010 about the said vehicle and its transfer of ownership. Again, while issuing notice, Sushant Pujari, he was intimated to keep the said vehicle under the custody of Inspector in Charge, Airfield Police Station, and surrender registration certificate. Again, while letter issued to Devi Prasanna was returned unserved with a remark so and so. Messrs. Tata Capital Limited had informed us that Sri Sushant Pujari had cleared the loan of the company on 13/4/2010 by paying rupees 5,60,000 and NOC was issued to Sri Pujari. The advocate on behalf of Sri Pujari had intimated that he has only received the order of appeal case on 1/11/2010 and already filed a writ petition for Hon'Ble Court by writ petition number so and so and awaiting for order. Also, advocate on behalf of Suchi Smita had appeared. Due to unavoidable circumstances, he could not file representation before the proposed 2 weeks. This was the RTOs. But thereafter, the vehicle registration was transferred in. High Court directed and it was transferred.
Have you got that appeal order? Para 7 you read.
Para
Have you
7.
got that order? Appeal.
Appeal order, I have not filed
Collector
it.
appeal.
Motor vehicle appeal.
Hmm.
The order.
Do you have that?
I am reading from the
No, para 7 up to that order you read.
case diary room.
You serve a copy and ask the IO to present on VC next week.
Next week.
Next
Because
week.
it's all are in Rathayatra duty.
Huh?
All are in the Rathayatra duty.
Rajatra is over yesterday.
Next week you will be.
Next week, yes. I mean, Mr. Palit,
Again?
I'll let him appear.
Oh, appear.
And meantime, you give that copy to him.
No, Friday din asu. Friday din asu. Visire to rahibe.
Visire. Yeah, I
Visire
don't
Friday
want that.
asu sadra by vikre.
So Rathayatra Niladi Vijay.
Okay. Next week you tell me.
Next week any day.
Any day.
Monday karan to.
Huh?
Monday karan.
20? 23. 23.
Fine.
Let the IO be present. Huh?
My lord, in this case, I am for OP3, my lord, it may be recorded.
Data fine.
Give it.
Data finance.
The IO of the present case is directed to appear before the court through VC on the next date appearing. In the meantime, the instruction received by the state, copy of instruction received by the state shall be served to Mr. Pali and leave the matter on circular.
In any event, my lords, I think your lordship is by now satisfied that I have nothing to do with this.
I understood it.
No.
Para 7 is making a better caseship of
Agree.
yours. So
Agree.
please see the para 7
Agree.
of that collector's order.
That order I have not
Okay.
seen.
I supply, I have given that. And let him come.
And the IIC will appear. Because
Virtually.
because
IO.
that it was submitted and perhaps he was not available. That the ID 2009 method.
No efforts, according to me, no efforts were taken to arrest him. He will not evaporate.
And let the IIC be here.
IIC, okay.
Instead of IO, IIC.
If he is arrested, then everything
Right.
is sorted out. Yes.
Yes, my lord.
At least, my lord, if he is not arrested, I may be released from the.
Then I am on merit, I'll decide.
Agree.
Then
Agree.
he is main accused basically.
Key copy maybe. I will-
Because see, the entire manipulation is done at two stages. One is at the RTO stage, another is in a bank, ICICI Bank.
And-
These people have nothing to do with that part.
And Tata Finance do.
Merely they are being accused because eventually the vehicle has been purchased
Yes.
by them.
And Tata Finance took a clearance from the RTO that there was no encumbrance. That also I have annexed in my
Yes,
read.
because the due diligence Tata Finance has done.
Yes, that.
By that time, they
no
will do
encumbrance.
the due diligence from RTO office. RTO office, everything is manipulated. The
Data-
Tata Finance thought it's all right. They gave the loan.
My lord, it is
Oh,
also surprising
what to
that
do?
all the records in the RTO office is not available. Because RTO in the
And-
in his counter stated that this record is not available in our office.
So the problem with them is that they go approach the Tata Finance. Tata Finance did the due diligence, whether any hypothecation is there.
Page
loan is
20,
pending.
page 20, your lordship will see of the writ petition, my annexure 3,
I found that.
that Tata
So,
Finance has clearly
Therefore,
given a
why
reply.
Tata Finance is helping today to them? Because their money is stuck.
My lord, informant
Semane
role is also by the
set to
secretary.
recovery only.
Informant?
Informant role is also doubtful. Because he stated that the Devi Prasad had sold this vehicle to the present petition. But actually the vehicle was in the name of the.
Just with that.
That
is
lady
informant.
only. Lady only.
She has must have been sold that vehicle to the present petition. How the Devi
No,
Prasad will sold?
that Devi might have manipulated everything, and this is very dicey thing, you know. So therefore, let the IIC come. But in any case, they have to be taken out of this
Right.
problem.
Grateful.
Yes.
Great.
My lord, free copy may be given.
The free copy.
Lordship may indicate the matter be
See, the
disposed of.
idea is to reach to the real accused.
Yes.
Not that because you real accused, you can't arrest. That doesn't mean that you bring anyone. Merely because they have the vehicle with them.
Since then he was absconded, till now he is absconded. Perhaps, my lord, I will.
Serious efforts will be done. Can arrest.
My
Yes.
lord, it will
And
take
la-
around 23.
Yes.
Lordship may
20.
indicate that it will be disposed of in 23.
Yes, I have done.
As far as my concern,
Yes.
my
I'll
involvement.
dispose it upon that.
Yes.
Yes.
Good.
My lord, 23.
27.
40.
Lord, sir,
My lord.
40 and 41 requesting for a password.
My lord, I may pardon.
Asking for
Yes,
pardon.
I concede with him, but instead of Passover, I pray Thursday after lunch.
Don't decide the.
I leave it to my lord. Say death reverse chalchi sorry ni. ସବୁ କୋର୍ଟରେ ଅଛି ମୁଁ କୁଆଡେ ଯାଉନି ସେଇଟା ହଉଛି ଅସୁବିଧା ତ
Last 3 months you have been taking adjournment.
ଚାଲିଛି ଆଜ୍ଞା ସେଟା ଚାଲିଛି 318 319 ଉପରେ କାଲି
Okay,
ଡିସିସନ
adjourn it to
ନାଇଁ ନାଇଁ ଥର୍ସଡେ ରଖ ଥର୍ସଡେ
Thursday ही करिए. Thursday all the boards is.
my lord may recollect 74 years discharge the vigilance judge has discharged the
You
accused
give an undertaking that death reference will be over by Thursday.
ଏଇଟା ହଜୁର
Thursday I will adjust my board and you will come and in the morning you will say
Adjourn.
death reference. And other people are waiting. So therefore let it come at its own pace.
ତାହେଲେ ପାଶ ବର୍ଷ ମୁଁ ସେଇ କୋର୍ଟ ନହେଲେ ଅନ୍ୟ କାହାକୁ ରିକ୍ୱେଷ୍ଟ କରୁଛି ଅଧଘଣ୍ଟା ମୁଁ ଏଇ କୋର୍ଟରେ ରହିଯିବି ବୋଲି କହିକି ଆସିବି
Next week, na? No, 5-6 matters, specially fixed matters are there.
ଓହୋ ସେଠି ତୁ
Let it come after 2 weeks.
ନାଇଁ ନାଇଁ 2 weeks ନୁହେଁ କି
Next week, though, not possible. Not A single minute is not available.
Next week, the board is very
I
taxing.
am,
See, I adjust the lease in such a manner that
Yes.
matters will not be adjourned. And if you ask for adjournment, what to do?
ନାଇଁ ନାଇଁ ମୁଁ ଆର୍ଜନ ମାଗୁନି ଆଇ ଏମ୍ ରେଡି ତାହେଲେ 500 ବର୍ଷ
He is also not asking for adjournment.
ସମସ୍ତଙ୍କର ଟିକେ ଅସୁବିଧା ଅଛି ଆକାଉଣ୍ଟ ସେ ଅନ୍ୟ କୋଉ
No,
କୋର୍ଟକୁ
therefore-
ହି ୱାଜ ହିୟର
Let
କୋଉ
it-
କୋର୍ଟକୁ ଯାଇଛନ୍ତି କୋଉ କୋର୍ଟକୁ
Okay,
ଯାଇଛନ୍ତି
Anyway, let it be.
ଆଜ୍ଞା ଆଇ ମେ
Yes,
ପାର୍ଡନ
yes, sir.
Item,
No,
item
the point-
41 will also, I am, in item 41.
Yes, I am requesting for pass.
Passover.
Yes.
After,
500 my lord is speaking 6 matters fixed at 2 p.m.
so
My-
in next week, Miller, any day in next week, Miller. Anyway, if it doesn't
In fact,
inconvenient to lordship.
that's,
It's not matter of convenient, inconvenient, matter of time, because the other matters
next
are
week,
not
my lords, the
fixed.
board is very taxing.
The board is taxing, it's not moving, you know, that's the problem.
My lord I pray one
We are
thing
exercising only what we are doing, we are
My lord,
listing the matter and getting it urgent.
on
That's not the
30th
idea
one-
of doing it.
I
Only on next day, after lunch, some.
then 6 matters my lord or fixed ଅଛି
We'll see.
my lord on 30
I'll adjust and give it.
my lord I may pardon 30th July next week ଟା ଛାଡ଼ିଦେଲେ 29th ରୁ ଆରମ୍ଭ ହଉଛି
We'll
30
see what to do.
I leave it to my lord
Yes, we'll just see, adjust the latest possible day with it.
Yeah.
Okay. Yes, next. Madam, it's going on, the password will come at its own, this thing, you know, wait. Don't have the habit of mentioning in between. Because there should be some decorum of the High Court. Please don't do it. Yes. 48. 48.
48.
My lords may be taken up in the weekly minutes, ready for hearing. Maybe tagged in the weekly for hearing. 2006.
See, the last order was, you are appearing?
48 item, my lord.
Yes, yes.
My lord.
The last order was non-appeared. It is made clear that next date of hearing, MAK will be appointed.
Yes, sir.
Are you appearing now?
Lordship, I seek for a passover, your lordship. My senior.
It's all right. Are you appearing?
Your lordship.
Okay, now put it in the weekly. So and so appears for the petitioner and seeks a passover. Leaves the matter in the weekly. Weekly.
Obliged.
49.
And make sure that next time you have to appear.
Obliged.
Yes.
49 I am ready
Yes, sir.
may I begin
The weekly matters, then we can say.
Weekly?
That's the bond is appearing as weekly.
Weekly. Weekly. Yes.
50.
Five zero. Basic director supply paper book to Mr. HV.
Already supplied my lords, I have
None
received.
appear for the appellant. In the event none appears for the appellant, the court will proceed with the matter appointing a magistrate. Just pass over, otherwise I'll appoint a.
My case, my lords.
51.
Item 51 kindly be taken up next week.
Why don't you write a judgment and give and sign it? You decide everything. Date also you decide. You have asked me the time for reaching. I'll reach it again. You are coming and ask. Where is your file? You show me. You tell me what is the facts. First, you must tell me the facts. Then only I'll let you.
Fact, ma'am, let's see.
No, every time you are coming and asking.
Let's
You
see
are
the appeal.
in Mr. DP Dhal's office.
Yes, sir.
You tell me the facts.
Let's see, the appellant was convicted under section 13E of 13E of Prevention of Corruption Act 1988.
Yes. Yes. Sentence.
Sentence 4 years.
Anything
And
else you know about
and
this?
Fine 20,000 in default of on.
What to do? The board is collapsing. Everybody is asking for adjustment. What? 51, na?
Yes, ma'am.
Is this 2013 matter?
Yes, weekly.
Weekly, huh? Weekly, yes. Three appeals are there.
Yes, madam. 4 appeals. 48, 49, 50 and 51. 52 is Mr. Das is here.
No, this is connected, all are connected. No, 51 is only two matter. 51, there are two appeals.
Same appellant. Same appellant, two appeals. He is appearing for that
Yes,
item 50.
then that will go to weekly.
Yes.
And what about 52?
52, Sir will argue the matter to at 2 p.m.
No, I will not allow to argue because 2013 matter you are asking adjournment and 2022 matter you will argue.
That's with the specific.
No specific nothing. Old matters you are asking adjournment. Fresh matter you will argue. Why should preference will be given to you? Tell your sir. The oldest matter, if it is listed, you have to argue first. 2013 matter, 2014 matter, you are asking for adjournment. 2022 matter, you are ready to argue. इसको urgent कर दो.
Let's say this is the
52
specific.
urgent for 3 weeks, and this include it in the weekly list.
Let's say this is the tag in the 2 p.m. specific urgent.
No, not that.
There is a noting malus में kindly.
Kindly
There's noting.
noting 2 p.m. at.
What is this matter?
Mr. Das.
It is a trap matter.
Why preference?
Preference is your lordship have been granted to please to grant order of continuance of no coercive action.
Oh, that matter.
Assistant agricultural engineer. He has been
Okay.
trapped in
There was a order of no course action.
no course.
And it is being
That's
interpreted
why
as
your
if
lordship-
conviction is state.
Yes. So,
That is the reason your lordship has.
and I have received 3-4 letters from the government.
Obviously.
So I am ready to argue the matter. If your lordship will hear, I will argue the matter. Your lordship may take it as parted and he may reply at 2 o'clock. Or if he comes, he will argue. I am ready to reply.
Okay, let us take it at 2 o'clock.
2 p.m.
As indicated.
Caption is
2 p.m.
As indicated. Yeah, there is an indication in the
Yes.
policy.
Yes. So 2 p.m. it may be taken up.
No, it will be taken.
But what had happened is the routine orders, no course action.
that is difficult.
Your lordship pointed that to clarify that order on the last occasion. So I am in trouble, my lord.
No, today what I'll do is I'll clarify that order. If the appeal is not to be heard,
Yes.
then I'll clarify.
Your
that
lordship
order.
may
No
kindly.
course action doesn't mean that it is.
Yes,
state.
It is state.
your lordship
It
may
is
clarify.
clear for the sentence only.
Yes.
Executable part of the order is sentence order, which
Sentence
has been
and fine.
stayed.
I pray before
May-
your lordship, if it is not had today, your lordship may only pass that clarification.
No, sir.
Let it be taken up at
2
2
p.m.
2 p.m.
2 p.m.
That's indicated.
Yes,
So
that
therefore I
already
can't.
indicated.
Yes, my lord. Oblige.
Yes, possible.
Obliged.
Passover, Mr. Das is there. His item is 37 before the honorable bench in court number 1. So he will come.
Okay, no problem.
30 after 37.
Weekly, let us.
Meeting after supplementary weekly item 101 onwards.
No, weekly. Let us see weekly. There is no thing.
Yes, sir.
Let us just run through the list.
Yes, 101 onwards it has caption. is there.
101 one. Once you want run through the list, then you can get an idea what to.
101.
101, no? Mapping.
This is a case of 376. The person has been convicted for 7 years.
Yes. Ready? Yes, Mr. Oda. Then we'll proceed. Yes. Yes, sir.
He has been convicted for 7 years. And after 3 years, 6 months, 20 days, he has been released on bail by the Hon'Ble court. My lord.
Please use the mic.
The person has been convicted for 7 years
7 years. Yes.
for the offense under section 376,
Hmm.
and also
Hmm.
a fine of 5,000 in default, rigorous imprisonment for the period of 2 years.
Hmm.
And also
Incident of which year? 2008.
2014, my lord.
2000?
2000,
No.
sorry, 2008.
2008. Yes.
Yes, my lord.
Hmm. Yes.
Allegation that on the 14th or 15th January 2008 night, the appellant raped the victim. Thereafter, she has been conceived and she miscarried.
What was the age of the girl?
Age of the girl was 20 years.
20 years.
Yes, ma'am.
No matter when she
Is a
adduced her evidence.
consent sex or what?
No matter what, her age was 15 years, my lord, by the time of occurrence.
No, my lord.
When her evidence taken, my lord, as P 1, my lord, age is 17. Deepika.
Deepa Patra.
Her age 17 years. When he deposed in the court.
My lord,
And so far case is concerned, my lord.
Are you prepared, sir?
yes, ma'am. Ma'am, she has stated that she is 15 years, but the doctor's report says that at the time she was 20 years at the time, more than 20 years.
The trial court believe what? Doctor's evidence or the prosecutor's evidence?
No, but it is a case, it is a peculiar case because I am raising that point. That point is not raised at the trial court and also the appellate court. My lord, the victim stated that on 14th or 15th of January 2008, while her mother was absent, and the victim was the foster daughter. And the petitioner is the foster father of the victim. That is the background. At the time of incidents, the petitioner was 25 years and the victim was 20 years. And the mother of the victim, who was kept by the petitioner, was 35 years.
Okay.
She has alleged that on 14th or 15th night, the petitioner has raped her. On that day, her mother was absent. Thereafter, her mother returned to her home. Then on 2nd of February, as because there was no menstruation cycle, her mother asked why.
The mother, what was the age of the mother? 35.
35 years.
If the mother age is the 35 and she is the natural daughter of the lady,
yes, my lord.
Then how do you say that she is 20?
Mother said
more than 20
35 years.
At the age of 15, she become mother.
Yes, but mother says he is 35 years. As per her statement.
The doctor's evidence is believed or the prosecutor's evidence is believed? Mr.
My lord, the doctor's report.
But the paragraph 6 is very clear, madam.
See, in a revision, we did not go into so many things. You just tell me the real point. Come to the point, I'll give you relief. Otherwise, if you go rigmarole like this, then revision has no meaning, you know.
And a particular doctor's
confirm it and two courts have held against you.
It is not a case of acquittal, my lord.
So you tell me what do you want. It's not a case of acquittal. Two courts concurrent finding against you.
More than 50% of the period has been undergone.
How much you have undergone? Come to the point. Unnecessary, why to waste time?
Out of 7 years, he is in custody.
How much you have undergone?
3 years, 6 months, 20 days.
3 years?
No, 6 months, 20 days.
Give the dates when he went into custody, give in writing.
Yes, madam.
What I'll do is, I'll confirm the conviction already undergone and send, what is the fine amount?
Fine amount is 5,000.
1,000 fine.
5,000.
5,000.
Yes, ma'am.
No, it's 5 or 6,000. 5,000 for 376 and 1,000 for 506.
506.
506.
Yes,
okay. Then I'll increase it to 10,000. Okay. Increase to 10,000 to be paid to the victim as a compensation. And insofar as his sentence is concerned, undergone.
Mr.
No. 376, I'm not doing PO, don't worry about it.
Sentence under.
See, I'll tell you, the 376 amendment, when carried out in 2013, I think, 2013 or so. So this is the incident of 2008. In the earlier provision, there was a proviso. By giving special reason, the sentence of minimum sentence of the 7 years can be reduced. By using that proviso,
Today you not this one.
I have one matter I have done it.
Two matters, madam.
Two matters.
11 and another.
By using that proviso, a sentence is reduced to already undergone. 3 years something he has already undergone.
Yes.
And increase the fine. Increase the fine. Conviction maintain.
My lord, there is point of law, my lord. So the doctor's report is not entertained at the trial court and also in the appellate court, my lord. Particularly that question I want to raise before this court.
How will you doubt the prosecutory evidence?
My lord, on 14th night, he has stated that she was raped. Then on 2nd February, that means after 17 to 18 days, she says that by the present petitioner, she has been raped. But thereafter, she was medically examined, and a medical report says that at the time of incidents, she was conceived more than 2 months. That means that either there is a free consent or by someone else.
That doesn't mean that the accused will escape, madam.
Because
No, what he says, 14th, she says that on 14th I was raped. And she reports after 7 days. But when the medical evidence was taken, examination was done, that time it was seen that she was already pregnant for 2 months.
Yes, madam.
So if at all there is a rape, it might have happened 2 months back.
That is true, madam. So far, this petition is concerned, madam. He cannot do escape, madam. So far, rape is concerned, madam. DM test is required for that. If he is not the accused, madam, so he has to pray for DM test, madam. That has not been done.
But he says that
Not claim, madam.
believe the prosecution in entirety.
Madam.
If at all a rape has taken place, it might have taken place beyond 2 months.
Yes, madam.
Madam, what happened, madam? The mother went to this accused, madam, petitioner, madam, and the victim remained with her parent, her father, madam. And again, the mother called the victim. He went to the house of the petitioner, madam. Petitioner committed rape on her. That is the allegation.
No, that
When she raped?
But on 15th, madam. 15th, madam.
But the medical record says that 2 months she is pregnant for 2 months.
Trial court, my official man, that doesn't mean, madam, this petitioner not committed rape, madam. How he escaped, madam, he has not committed rape, madam. Even if madam she is pregnant, madam. So far, rape is concerned, bhakti bhasan is sufficient, madam, to convict him. And also doctor's evidence there.
No, doctor.
Doctor evidence is not
Yes,
there. He says.
Madam.
PW doctor?
Madam.
Which PW?
PW 6, madam.
6. Let us read 6.
Para 10, madam. Well, deposition is, I have given the deposition, madam.
Give me.
Well, give, madam, I have highlighted, madam. That the
Deposition you give me. The secondary sexual character were double up. Areola of nipple were black and prominent, as well as on examination of her genital, the appearance was found to be normal. No breast bleeding, not motive, and over old tears of division canal was admitted. Where does it say that 2 months pregnancy?
My lord, can I have a glance with the medical jurisprudence also?
Huh?
The Modi jurisprudence. Modi jurisprudence says that.
More, tell me the evidence of PW that the doctor, where does the doctor say that she was 2 months pregnant?
As per doctor's report, there is a Montgomery test.
Inference, direct evidence, you tell me the direct evidence. You
Rather-
can't,
Rather, my lord, the column number B,
hmm.
the vaginal
She
canal was admitted.
doesn't whisper about it. The doctor doesn't whisper about it.
No, my lord, the doctor said, mobile report only. My lord, in paragraph 1, triple I, the areola of her nipples were black and prominent, as well as Montgomery tuberculosis that is generally developed during pregnancy were present. And that Montgomery
Areola of her nipple were black and prominent, as well as the
Montgomery
Montgomery tubercles
generally developed
during the pregnancy.
Developed during pregnancy.
Then where is 2 months?
And this will appear in between 8 to 12 weeks that has been reflected in the Montgomery. Yes, madam.
It doesn't very why where was your cross examination? Where is your cross examination?
Now
you try
particularly that point I have raised. It was not raised at trial court and also.
Be happy, don't go to jail. Pay 10,000 rupees. Conviction maintained. Sentence reduced to already undergone. Fine increase. Link do
Poor fellows. 6,000.
No. You paid.
Delivery level on manner.
It's a 376.
Yes, madam.
Convicted by 2 courts. Till I am giving leniency to that text and give you the date of custodies. And write down the sentence already undergone. Fine increase to 10,000 rupees, and he will give you the dates of.
He was arrested on.
You give, please give in writing. Yes, please give it right. Yes. Yes, Ms. Das.
Yeah, Lordship permits, my lords.
Pass over.
My lords, item 40 and 41, my lords, of your lordship cost list, my lord. 40 is of the year 2008. It's a state has preferred this revision, my lords.
What is that revision?
Item 40, my lords. And my lords, item number 41, my lords, is also a state case, my lords. State has preferred, my lord. In both the cases, just lords, 1 minute. My lord, in item 40, my lord, I will place para 3, 4, 6, 4 to 6, and in item 41, I will place para 3, 5, 6. I assure this on court, both cases will disposed of, my lords.
I'm ready to dispose of right
But
now.
I'm told that it's both, and my lords, I will place only 3 paragraphs, my lord. The case is filed 2008, my lord. I hope that today's my
dispose up in favor of Mr. Ponda.
No, I will not be vocal like in that process. I will place that if lordship and dispose the
You bring him.
Yes.
A charge 2009 when the FIR
exactly. I'm on the. I extend all solid. Correct, lords. I stand today.
You call him. I'll hear it. Call him. I have no issue. That perhaps the reason it was kept for today.
Oh yes, lord. All the old.
Every time he comes and says death reference and all.
Death reference today. Today. Oh shit.
And he will come. We'll call him for 5 minutes, 10 minutes. I'll dispose it up.
I agree, lords.
102. Yes, 102.
Yesterday in matter, my lord. Then call my lord. He asked for adjournment, Mr. Naik.
103 crore. 104. 103 just now he argued, no?
Here, 101.
103 which one?
103 yesterday.
One second.
No,
103. चलो आगे चलो 104. Nobody is there.
105. 104 my lord. Yesterday it was in this time that I mean adjourn.
No, let it be. 105.
105. 105 also yesterday my lord call. The matter was called and the time adjourned.
106. Let us go through once. We will understand.
Appointed amicus, 105.
5.
Appointed.
Not 5, huh?
His age is.
Huh?
He is also near 78 years age.
Now, where is the proceeding is not placed? Just see.
I just
Appointed.
found out.
Huh?
I have just found out from the case records.
No. If MH is who is appointed again? Check it. There is no proceeding here. What to do?
I have marked it.
Just see if I have already appointed, then
There is no indication in the order, but I have marked.
just see order might have been there. Just see, check it out. 6.
106. 490 34 commission that has also been yesterday adjourned.
Hmm.
One of the last.
So let it be there. 107.
107 and adjourned.
Ah.
109.
9. This is very old matter. 9.
Last week you also happened amicus.
In this matter,
No, last week onwards.
we appointed already.
No, man. We have, you have.
Just see, in this matter, who is there?
109 was, last it came 6/5 2011.
109.
109.
What was the proceeding? Have I noted to appoint?
11 last time.
Okay. Non-APS therefore, non-APS for the 109. Non-APS for the petitioner when the matter is called in the interest of justice adjourned. Huh? In the interest of justice, shall we adjourn for next week? Huh? Adjourn for next week. So is least next time we will appoint amicus.
May mention they did not appeal.
Yeah, if it is made clear that in all the matters you write like that, wherever I am saying. It made clear that if none appears for the petitioner in the next date appearing, the court shall proceed with the matter by appointing amicus. Yes, next.
110.
In all the matters we will pass this. 108 we will not consider. Same order. Non-APS for the petitioner. Next week, right? Next. 100.
111.
It was listed on non-APS for the petitioner. In the interest of justice.
Earlier occasion also non appears.
9/7. Justice adjourned to next week. Same.
112.
I will petition sought none on the last date of hearing, that is on 18/10/2023. The petitioner has sought an adjournment. Today none appears for the petitioner. In the interest of justice, adjourned to next week. In the event none appears, court shall proceed. Okay. Next.
113.
सेम कर दियो सबुरे कर छाड़ी दीथिबा तब देखिबा
Next.
हां
114. $376. 7 years comes.
same out one piece. Yes.
115.
They don't have copies of necessary document. Yeah, right. Non-APS, same copy.
Registered directed to
Supply the
supply
copy.
copy.
पाइले आपण Last,
my lord, already
the order dated 24/6/2024, directing the registry to supply the copy of the paperwork to Mr. Ragada has not yet been complied. The order is reiterated, at least the matter, sir. Next, non-APS for petitioner Kodala. Yes. Next.
116.
Yes. Same order. By the order dated 24/6/2024.
The item number 115, my lord, copy received, my lord.
Received, na?
Received.
Non-APS for the petitioner.
115.
Not for APS for petitioner. It 116, na?
115, earlier.
You received.
Copy.
Already complied, yes. Non-APS को same कर दियो. 16 रे पहले.
16.
Copy.
16 copy.
Copy अच्छी.
Already, my lord, already.
Non-APS पर. Same order कर दिया.
Last time non-appeal.
117.
I beg your pardon, my lord.
Yes, Mr. Panda.
Item 114. Can you be adjourned to next week, my lord, any day?
Already.
114, my lord.
Yes, Panda, we put in. Yes.
113 ଟା period under ହେଇଯିବ ଫାଇଲ ଟା ଅଛି
But he is waiting for you.
ସେପଟେ ଆଜ୍ଞା ଗୋଟେ ହେଲା ଗୋଟେ 302 ସାରିକି ଆସିଲେ କଣ କରି ସବୁ କୋଉଠି ଦୌଡୁଛି କୋଉଠି ଯାଉନି ଆଉ।
ଏଇଠି ଦୌଡ଼ ମିଶ୍ର।
Junior ରଖନା जो
You don't keep juniors and this is bound to happen.
They are engaged in other course. 113 dispose of ହେଇଯିବ. Last time I have argued, my lord has directed me to verify the LCR. How many days in custody?
113.
113 টা মানে।
How much undergone? What is the offense?
Punishment 354, 323, 324 RPC.
Yes, sir.
My lord.
Undergone.
They have undergone. They were
RI for what?
arrested on say 15 days in custody, released on bail.
15 days.
15 days.
Total.
My lord. Released on bail on 7/10/2004, my lord.
But 15 days you have undergone.
My lord. 26/9/2024, date of arrest.
Then undergone 15 days how can you? 324.
1 year punishment.
You act.
Incident?
Incident of the year 2004. In the middle 20 years.
Yes,
happened.
Mr. Ragada.
Right.
But increase the fine.
Oh my lord.
Increase the fine.
My lord.
10,000 fine. PO.
10,000. I guess.
You are appearing 10,000.
3 injured persons.
Huh?
3 injured persons. Lady also, one lady is there. Injured, among the injured.
So 3,000 each, 9,000. 3,000 each. 9,000, 3,000 each. 3 injured persons, 3,000 each.
Total, in total, there are 2 accused persons. Out of 3, 1 accused has expired. Here, 2 accused persons.
Okay.
And in total, man.
3,000 each.
3,000 each
No,
is injured.
there are 3 victims. 3 victims. Conviction is 324.
324,
333.
324, 354.
324, 354.
And 323.
What is the age of these petitioners?
35 years in the year 2011. Another is 30 years in the 2000. In the meantime, 13 years. 35, 48, 43, 44.
They should pay you. Little cost. Anyway, we'll see. Okay. Judgment reserve. Yes, yes, Mr. Das. He wanted to.
Mr. Panda,
matters.
ତମେ ଯୋଗୁଡା item 14 appear କରୁଛ?
ହଁ.
40 supplementary.
ହଁ.
Boss.
Yes. 40 supplementary shown. Yes. Discharge by the order dated
This is 11/2005.
2005.
I'll just place it for Lordship, paragraph 4.
4 of the order.
No, from the petition itself. Lordship, turn to page 2 of the petition.
Yes. Yes, para 4.
I'll just place para 4, 5, and 6. That's all. Lords, that includes the factual aspects also. It will Lords, a Sikh industry unit, it called Piping and Engineering Works Ltd was put to sell. An advertisement was published inviting applications from the intending applicants to take over the unit. In persons to the advertisement, one E.V. Prasad, posing himself as the MD of Messrs. Vrindavan Engineering Private Ltd, Hyderabad, made an offer on 31st January 98, offering his willingness to operate, maintain and market the products of the unit. Board of Directors of IPWL resolved to send an officer to visit the work site and Mr. Prasad to find out his worthiness and expertise in the relevant field for which the present opposite party was selected and deputed. The opposite party for this on court notes was to ascertain notes. The present opposite party visited the site Messrs. BEP Ltd Hyderabad during the period from 23 to 98 to 28 to 98, and on his personal and on the spot assessment submitted a report on 6/3/98 in favor of the unit Messrs. BEP Ltd. Therefore, the report of the opposite party, who is the only officer availing the opportunities having personal on the spot assessment, was considered in the board meeting on IPWEL on 9/3/98 and on 20th/4/98. In its 24th meeting of the board, ultimately decided to hand over the unit to Messrs. BPL Ltd, of which Mr. Prasad was the managing director for operation, etc. According to the said decision, an agreement was entered into, and Mr. Prasad was inducted as director operation of the Sikh unit. After his induction, a sum of rupees 11,18,067 was received by Mr. Prasad as advanced to meet the expenses towards payment to outsiders. During internal audits, it was detected that as against the said advance of rupees 11,18,067, only a sum of rupees 2,58,742 was justified and accounted for, while the raised amount of rupees 8,59,325 was misappropriated. But they said Mr. Prasad absconded. Doubt crept in about the bona fides of Mr. Prasad and his unit BEP Ltd, for which one S.C. Samal, senior manager, vigilance, it called, was deputed to verify the credential. Accordingly, C. Samal visited the worksite Mr. Prasad during the period 6/2/99 to 19/2/99, about 1 year after the visit. I am placing page 3, notes.
Yes.
Page 3 of the petition, notes. About one and the 6th line from the top. 19/2/99, about 1 year. Did your lordship get it? 1919, about 1 year after the visit of the opposite party to the said site, and he submitted a report on 20th February
He
1999.
has given a wrong report. On that basis, the case was registered. There was no existence of BHEL. Yeah, what is that?
Since I confined my submission only 3 para, let me place it. He submitted a report on 20th February 1999. The second manager of the manager, it called me, has visited notes. To ascertain the veracity, was found at its official address at Amripet, Hyderabad, and at his industrial complex at Chidimatla and shed of number so and so. The IO during investigation was also visited the spot and arrived at a similar conclusion like that of Mr. Samal. Accordingly, the charge sheet was made against the present opposite party for being acted hands in gloves with the said Mr. Prasad, for being instrumental in leading the board of directors to allow the said Prasad to withdraw lakhs of rupees by way of advance, relying and solely based upon the report submitted by the present opposite party, which appears to be palpably false. that it may be pertinent to mention here that while considering the petition under section 239 CRPC, the accused opposite party, the law and trial court, has not addressed itself to the facts and laws of the case in its proper perspective and allowed the petition against the settled position of law that at the stage of framing of charge, it's not to weigh the pros and cons of all the implications of the materials presented by prosecution. Even a strong suspicion leading to a presumptive opinion as to the existence of actual ingredients ought to have been taken into account to frame the charge. That on simple appraisal of the materials on record, it is clear that the Board of Directors, IPW, had based its decision to hand over the Sikh unit to Mr. Prasad on relying on the solely basing upon the report of the present opposite party, and it's incorrect to say the present opposite party had no role to play in the transfer of unit to Mr. Prasad, and that the charge as laid against the opposite party was groundless. Rather, the prosecution has collected sufficient materials and evidence during investigation to establish that both persons have conspired together to cheat the government and misappropriate 8.6 lakhs of government money to the peculiar advantage of the accused number one. Hence, the order of discharge is not based on good and substantial grounds. The impugned orders, is dated 26/11/2005.
Come to page 10, para 7.
Para 7 starts, so far as the present.
Yes.
So far the present accused is concerned, no allegation has been made about the commission of criminal misappropriation or cheating by himself, but the allegation against him relates to criminal conspiracy under section 120 IPC. Consequently, committing
the report which has been given, you said that is the basis for which the Sikh industry is taken over. And the finding of the court, that is not the sole report on the basis of which the Sikh unity is taken.
And he was also.
Therefore, he was discharged. What else you have? Nothing.
May complete the para 7?
I read it.
Lots of record my
Anything you want to add?
record my submission, particularly the grounds have taken.
Definitely.
Deep lobbies.
And 2005 discharge, and now you want them to, yes. Done. Both the case, same?
No. Lordship, it has 41 in
No, 41 nahi. 41 Mr. Bhavan Das. More khali 40 ta.
40 judgment.
Oh, bless.
See, which is better, death reference or this?
Well, with due apology, I could not follow.
Say thank you.
With
Which
due
is better?
apology. Kali ete board, mo rati 4 kali soichi.
Leave it to some juniors.
नहीं ताको छोट matter सर ताजी vigilance को तो question लेके छाड़ ची.
And what is the next one?
The next one is also a smart
This
matter
is arising out of the same incident?
against the order allowing discharge application.
Huh?
But here is an interesting lot.
No, what about, it is not related to this?
No.
It's something else.
Here the accused opposite party was a law officer. But I was the state counsel from 95 to 2000. He was coming as a law officer of one department. But in a
He is a lawyer now.
She was a law officer in the particular department. She used to come to the advocacy office. I was there for 20 years in the advocacy office. She used to come, but in this particular case, very famous case at disproportion matters, that Muduli matters, Bichitaranda Muduli matters. When the house search was there, my lords, huge amount of a suitcase containing huge amount of ill-gotten money was found from the quarters of these opposite party members. And anyway, my lords, I'll place it.
This was 2009. Discharge.
I was ready, my lords, but I don't know who.
Okay, this is urgent to next week. Yes, this much. You have mentioned.
I may leave, man.
Yeah, definitely.
So 40 is reserved, my lords.
Huh?
40 reserved, my lords.
Just now I will give. Yeah.
Or should I mention the date of disposal today? Today's date of disposal.
Today dispose. Today dispose.
40 dispose.
Just now I give it now. But today whatever I reserved before lunch, I will give it. Just now I give the order.
Yeah, my lords.
Yes.
Paperwork is prepared. Section says that if the file goes with the direction of the honorable court to hand it over on deposit of nominal official cost.
There were 3 appeals, huh?
Three or two appeals have abated. There are the two teachers.
Why did you argue? We'll finish it up.
No, the paperwork is not with me. The section is not handing it over. It is in my lord's file.
Give a paperwork.
No, the cost has to be deposited. If it goes to section.
Give a paperwork. I'm just giving a direction. Right now, the registry is directed to supply a copy of paperwork to Mr. Das, legal counsel appearing for the petitioner. Matter is ready for hearing. Raise the matter. When do you want?
We commencing 29th, man.
29.
Or next week it can
It will
be.
be next week. Small matter. There are 3 appeals. 2 appeals already abated. Let us see if any material is there or not. We can dispose it up. Put it in next week anytime. Okay. Collect the paperwork
By
today,
Friday, by
tomorrow.
Friday.
Yes. No problem. Yes. Yes, sir.
Your Lordship, item 34 was specially listed at 2 p.m.
33 also. 33%. Yes, Mr. Naik. See, 33 is also listed at 2 o'clock. Let us see. 33, who is appealing?
May I please?
Yes.
Last occasion directed the Vigilance Council to obtain instruction. This is
Yes.
regarding rejection of 457 application. My laptop has been seized where I am
Yes, yes. That laptop issue.
Matters.
You got the info?
Yes, I've got the instruction notes.
Yes.
Lords, before I place that instruction note,
Yes.
I would like to bring your lordship attention to page 35 lordship brief notes.
35.
Just to refresh your memory, I have placed on 2-3 lines only. Page 35.
What is your instruction? Let us understand.
I'll apprise my lords with a short, but it starts from this particular one line. Page 35 lordship lords. Last 2 lines, lords.
Yes.
It says that it is contended that the principal accused is in habit of acquiring ill-gotten money and that the accused was doing cryptocurrency business by using the said laptop. It is further contended that the father of the petitioner has made investment in 88 cryptocurrency wallets. Lords. Now, lords, we turn to page 18, lords. In that particular list of assets, lords, movable asset at page 18, lords.
Yes.
Because the lordship would like to know what is the exact value of this 88 cryptocurrency wallets.
Interested in that.
Well, I'm placing lords. Just to 1 minute. Page 18, lords. I'll come back to the exact point lordship wanted. Page 18, lords, serial number 22. Serial number 22 said the investment on cryptocurrency coin digital assets is 1,75,55,607.
That may be correct. That's not the issue. Issue is
Only
here
a
something
reflection,
different.
my lords. Now,
Tell me the instruction. What you want? See, the father has been doing all this thing using his laptop. He is the son. He's not been accused. Okay. This laptop is his office laptop. He wants to give it back to the office. You retrieve whatever data you want, give it the laptop.
In this particular process, not. I'm placing the difficulties, my lord, because in this particular process of digital currency, my lords. Lordship, let me place that. There is search and seizure operation conducted by the at the residence address of Mr. Nihar Ranjan Das, the main accused, principal accused, on 28/10/2022. A total 39 wallets were found from his custody. The said wallets were in form of laminated documents which contain QR code number and a pass phrase or private key. These wallets can be accessed by scanning the QR codes, followed by entering the PIN codes, 1, 2, writing the pass phrase or the private keys, that is alphanumeric codes mentioned in that laminated sheets in the same manner and predefined orders only. Such pass phrase, private key are an arrangements of 12 by 24 random words arranged in a particular manner or combinations of numerical values. It is not possible for a human mind to memorize the same due to its complexity and length. Therefore, the accused had maintained a particular handwritten diary to keep a record of all these wallets. It is possible that the accused has kept a written record of the same in the seized digital device. As a result, if the custody of the device are given back to the accused, he and his accomplice may access the wallets in question and withdraw away the funds as accrued therein.
Para 4 is important.
Then para 5, such unauthorized access is possible when the accused is given custody of the seized device, resulting in changing the status quo of the wallets in question, which are also the subject of investigation. Let's turn to next page, Mods. I'll be bringing, because I want to be enlightened by this particular cyber law notes. In order to prevent any further change in status quo of the wallets due to the unauthorized access of the wallets by the accused, the defense seeks to extract complete and all the data available in the device by FSL laboratory and format such device, therefore become handing over as access in any manner is prejudicial to investigation. If the applicant counters that I have personal information and data stored.
He says that formatting is not possible.
It's not possible. And secondly, lots of kindly bear with me, lots. The entire system, lots, like I keep some money in my bank, then some interest accrues, lots. This investments of ill-gotten money, which is stacked in this particular wallet business, lots. This 88, I placed before lordship. 88 crypto wallets.
Lordship, kindly have a glance to page.
When are you going to file charge sheet? Let us come to the point. When are you going to file the charge sheet? Because during investigation, this device may be required because if formatting is
even
not
during
possible,
seizure, they have not seized my laptop.
Some data may be required.
And in that process, the last instruction I received that in the process of transfer, lots, the entire thing will be erased. And secondly, lordship, with the important line, I am unable to resist the temptation of placing that particular instruction, Lord. This particular deposit in that.
Anyway, the last paragraph, you read it, it says that 8 to 12 weeks is required for scrutinizing.
No, he says, if he says that he has some personal data there, that particular time is required to furnish that data for if any person. The reason being, the system recognizes that particular hardware, that particular laptop, and this particular deposit will like the interest is accrued on my bank accounts. This deposit wallets will also.
When was the FIR?
The token is
10/20.
Token is generated, Milords.
20/10/2020.
Now come to the point. When are you going to file the charge sheet? It can't go on and on and on. You tell me when are you going to file the charge sheet? Otherwise, I pass a direction to release it.
No, will that definitely I'm with your lordship, Milords, to expedite. Correct. Milord,
device belongs to some company, and you have a right to investigate. No problem, but.
Charge sheet should be expedited. I agree with your lordship.
How many years?
I'll come back to your lordship, Milord. What is this time, exact time they require?
October 22, the FIR.
Yes, Milord, 22, Milords. And Milord, in this case, Milord, but last 9 placing, Milords.
And
now
they have
the amount deposited in that wallet, Milord, it's being handled in the headquarters in foreign countries, Milord. Now, that particular deposit generate a token. Like that interest, and the token is being kept in a government account to SIP security. Now, that particular system understands or recognizes the particular laptop seized, Milords. The moment is changed.
That's what you complete the investigation.
I agree. I entirely agree. Lordship is correct. Lordship fix a date. I'll come back to your lordship. At what time exactly can be expedited?
Pursuant to the last order, and he seeks further time
to apprise
to apprise the court regarding the
timeline tentatively required.
Tentative timeline to
complete
the investigation and file the charge sheet. Leave the matter 1 week, leave 1 week thereafter. And it is made clear that if the department is not able to place on record the exact timeline for completion of the investigation, this court will proceed with the matter.
No,
on its own merit, and
the reason people are there
waiting for further.
No, they are desperate this particular laptop because the token is generated.
They have
this is.
I'm not saying you don't do. You must do it.
Yes.
Must do it. It's a very serious offense. You must do it.
They have
Not
seized
saying-
5 laptops, my lord. I am not praying for release of those 4 laptops. Those 4 laptops are my father's laptops.
This is the way you are. The token is generated and you want to
The instruction
encash at
indicates
once.
that the particular device identifies.
It cannot be, my lord, because the software is downloaded by the company.
No, not software. Yes. That's being placed into for illegal
On
motives.
your lordship, kindly seizure list that has not been seized during seizure, that was seized thereafter, my lord.
That is again
Yes.
on merit.
Yes,
Let us see
yes,
if
my
they
lord.
can, insofar as this
My lord.
device is concerned,
My lord.
let them complete the investigation.
Let them
If
come.
all the
let them
devices
extract-
are there
yes.
with you, only one laptop. One laptop, you, insofar as this is concerned, you complete it. Unless there is a pressure, these people don't do. They pick up everything and keep quiet.
Your lordship order will be complied, my lord, but lordship can be with one line, my lords. This particular device was sent for that.
I have taken on record your instruction.
That this device was sent for that sale.
Listen.
That particular sale is that cyber sale, my lord. But not for examination. That's for exam that is come back. Now the prosecution says that this device get the benefits. The benefits generated is the token generation, and that token is been kept in a particular government's accounts, my lords. Now he is desperate to get one, to get that, because the central that headquarters in foreign countries, my lord, recognize this particular
Where have you
device.
sent this? Where have you sent this for? Where have you sent it?
No, we have sent it to cyber cell attack, not it has come back with regard to that examination. But the money which is generated, I mean, that interest is, the token is generated, my lord. That way he is interested for this.
Anyway, you do it.
Because that
It's very technical thing. Why to write?
I also, my lord, I am also being enlightened.
Very technical thing.
But I will say, definitely, my lord, expedite the process of completing.
Next. 34. 34.
34, your lordships. For your lordships, last to last order, your lordships are directed that no further adjournment will be given in the matter. After that, your lordships, it was listed paragraph 20, page 12.
I'm not adjourn. Do it. Do it.
You cannot do it. You cannot do this.
For the Milord, in this case, Milord, actually notice was not issued, the cancellation bail. My lord was pleased to direct past order, so appeared.
You appeared in the first day.
Yes.
And
last week I appeared. My name was recorded for the sake of the cause list to miss.
No, before that also on 6/4/2023, you had briefed the senior counsel, Mr. Manoj.
That I wanted to clarify.
Who had briefed? You had.
Yes. No, that once, Milord, the modification of bail condition was listed before my Lord Justice Sangam Sahu.
It doesn't matter.
Modification bail was sought for by the present accused in the year 2020-23.
What was the modification?
Modification that he was directed to appear before the IO on each Monday. That condition was, my lord, heard. 2 occasions, while the matter was taken up, the CBI counsel and in counsel told that the modification may not be done because there is a cancellation bail is pending since 2021 that the accused has violated conditions, supposedly. So, for the sake of, my lord, this matter was
is still pending.
No, that was allowed. Only
allowed,
for,
and what was the modification?
Yes, I am giving modification.
Show me.
No, so that modification has nothing to do with this
Just
cancellation.
let me, sir.
Let him come.
No, just let me. What pity? So, move to set court pe. Kai pity jo. Yes.
Rather, your lordships, was. Rather, your lordships, was trying.
Reference secretary case ta astila. Mu kahi clarify kurchi. एथरे कैंसलेशन बेल आज्ञा लोकर जीवन पळेबो लिबर्टी अछि फंडामेंटल राइट अछि नोटिस आज्ञा
जेल रे जीवन काहे जीवो जेल रे खाया पियो
आज्ञा सो बहुत कष्ट रे आज्ञा ही हैज रिलीज्ड एनीवे आई डोंट वांट टू दिस केस वाज लिस्टेड फॉर मिलर्ड modification purpose. The order can initially Milord kindly see modified. And this case,
what is the condition now?
Condition now, he is not appearing before the IO. As and required, he will be called, he will be appearing.
When he was appearing, he was threatening.
No. That is not the
that
IO.
Is the allegation there.
Yes, allegation.
And the IO was summoned and he appeared and he also said the same thing.
Your Lord, the IO is still here?
At that case, today you are appearing. That is one of the filing bhokla.
So the first.
Yes, kindly.
Jyoti first give.
The bhokla.
You say, have you given no objection then?
No. My friend is today. I'm in this CRLMA. My friend, Mr.
May I take 1 minute of the
Yes.
Lord? It is
No,
not that-
you are appearing or?
I'm appearing.
Yes, please,
I'm
address.
appearing. I have filed my Wakalatnama. I have put my
You
signature.
are,
Wakalatnama.
you have to give no objection then.
The fresh Wakalatnama is filed in the CRLMA along with this my friend's name.
I'm just.
No, let's forget about the technicality.
Yes,
Let us-
yes, yes.
let us-
Yes, we'll assist the court.
This
Yes.
is the case, my lord. It is not the rejection of bail, but the
Your Lordship,
cancellation of the bail, my lord.
Your-
So, my
my
lord, what my
application-
commission is,
Your Lordship, this
allow me
my-
to file my response to this petition so that all the records should come before the court. Then the court may take whatever the decision has to be taken, my lord. But my legal submission is, my lord, once this honorable court has given the waiver in the condition, keeping in view my wife's health suffering from the cancer, I think clause number 5 of the order. So at that time, this situation was before the court. So court has already taken these conditions. Court have already observed this, that the cancellation of bail application is pending. So court, when given the liberty, it means automatically the court has considered this.
No,
Now,
Your
my
Lordship,
lord,
automatic.
second option is, if my lord go through 437 clause 3 subclass C, this
Your Lordship, this cancellation bail application has been filed by me. I am supposed to argue. How he is starting his arguments without hearing my arguments, Your Lordship, I cannot understand.
I'm just assisting the court. I'm not arguing, my friend. I'm just seeking an opportunity so that I can argue.
Mr.
Your
Naik,
Lordship, Your Lordship, I
instead
kindly.
instead of going into all this high fund argument, bail is granted, and you move appropriate application with trial court for variation of any condition, depending upon the changing circumstances. Finish it up. Why unnecessary?
No. Paragraph 20 for a moment. You cannot do anything. Even I do not appear before you. I know how to manage the High Court. If you report against me, I will also make false complaints against you. And like I did before, why should Your Lordship, the Superintendent of Police, has filed an affidavit? I know how to manage the High Court.
Allow me to read the phrase because he has read something
He has
very.
written please wait. Please wait.
No, these are the diary entries.
I know how to manage the High Court. Let him explain.
It is the hand of what happened, my lord.
No, IO will do all these things, threatening to the
what
High
happened?
Court and all the. No, IO will do that.
Kindly allow me to argue why he is interfering, Your Lordship.
Of the IO, I have given at least 130 times I appear before the CBI, my lord. Kindly take a minute for page number 40. What they are banking upon. Page number 40, my lord.
40 of your petition.
40, yes.
Their petition.
Their petition. I have not filed any reply, my lord. Kindly see how they are manipulating the things.
Wait a bit.
First, before coming on 40, my lord, I will just.
You manipulated everything to commit the crime. They are manipulating everything to nail you down. This is what going on. And why you are wasting court's time?
Yes, I'll file my response.
I will simply say that in the face of the allegation made against the opposite party by the CBI is granted liberty to move appropriate application before the trial court
Without observation.
and apprise the court regarding whatever has transpired and modify the condition if it required.
No, Your Lordship, Your Lordship, the bail has been. What, Mr. Lalit, please. Your Lordship, the bail has been granted by the High Court. We are seeking a cancellation of bail, not modification of the conditions, Your Lordships. And Your Lordships may kindly hear me. What are the arguments which I am making? Then Your Lordship may pass any order. And Your Lordships, in a cancellation of bail which is filed by me, how can the opposite party start argument without hearing me? Let me read. Your Lordships. Let me read, Your Lordship. Let me read it again. You cannot do anything, even if I do not appear before you. I know how to. And he is saying that both paragraph 20, Your Lordships, is a part of case diary.
20 of
my petition, Your Lordships, and also Your Lordships have given the case diaries with the flag.
Let me reach there. There.
Yes.
20, yes. 20.
Yes, Your Lordships. You cannot do anything even if I do not appear before you.
This is the allegation of 2021. 2021, they have filed.
And Your Lordship,
yes. The case diary was called. Honorable Court also keeping
which part of the order it is written in the modification application that I have perused the case diary? Lordship may record his submission. He is making false submissions that the case diary was perused and Honorable Court knows it.
Where is the case diary you have filed? Where is that?
Case diary, Your Lordship, is there. My junior is there. And in fact, Your Lordships, if Your Lordships will come to paragraph 21.
Where is the case diary, madam? Where is the case diary?
Your Lordship, the IO is also here, Your Lordships. Your Lordships wanted to hear the IO. Mr. Pradhan is there.
IO last time appeared, I have asked him.
Now also the learned IO is there, Your Lordships, is online.
Now you are appearing before the IO.
Yes, sir. Appearing and seeking some
Mr.
intelligence to
Pradhan.
file my response because one side is recorded on the court, another side is recorded is not there, my lord.
You got the concession of bail. Why are you indulging in all these things? It's very serious
Never, my lord.
thing.
Never will.
And I think, Your Lordship, one
plenty.
IO was filed. Your Lordship, one IO was filed, IO number 856 of 2019, with a prayer to modify condition number 5.
Okay, you have not paginated, madam. He is referring to some page and you have not paginated.
No, Lordships, these yellow pages are all the times when he has threatened.
How 20, huh?
No, page
Black
20
20.
page 20 of my petition, Your Lordship. Your Lordship, may kindly read the petition. I have quoted it in my petition.
You have page 20 is prayer.
Paragraph 20, page 12 of my petition, Your Lordships. And it is,
Okay.
yes,
Okay.
page
1,
12.
2. 1, 2, okay.
Yes.
And you tell me one thing, do you have any objection to that this diary entry, I'll give it to them, they will respond to it?
Because under 172(3) of the CRPC, the accused or his agent doesn't have any right. It will be given at the state of 20.
Yes.
You cannot do anything.
That is why I asked you.
And why is making the submission both cost or bail bill? What does that, Your Lordship, what does it mean both?
Para 12, para 18.
Para 20.
20,
page,
okay.
Yes. That on 5/10/2018 at 2:50 p.m. the accused came before CBI office and started abusing the CBI officials by saying that you cannot do anything even if I do not appear before you. I know how to manage the High Court. If you report against me, I will also make false complaint against you, like I did before Special CJM CBI Bhubaneswar previously. Then Your Lordship may kindly come to the next paragraph. Next paragraph, Your Lordship, the matter was listed before some other bench. He made a false
Is he a lawyer by chance?
No, Your Lordships. He's a journalist.
Language looks like a lawyer. Yes.
That the respondent accused had filed an IA. He is being briefed by good lawyers, Your Lordships, while threatening. That the respondent accused had filed an IA 856 of 2019 with a prayer to modify condition number 5 and to waive it.
Yes.
There he made a false submission before the Honorable Court that the investigation is over, Your Lordships. When the investigation was pending, the court took cognizance of the fact that he was lying before court and investigation was not over. This IA was dismissed, Your Lordships. Video order dated
173(8) is open.
Yes.
Otherwise,
but
charge sheet is filed.
Charge sheet is filed. This 6/1/2021 order has been annexed by me, Your Lordships, when the court has stated that he was lying and court recorded by submission and this IA was dismissed. Now, Lordships, he is also threatening the witnesses also. The witnesses, Your Lordships, has given complaint dated 22/2/2021, which is annexure 5. If Your Lordships will see page 39, 40 and 41, these are the threatening of the witnesses, Your Lordships. That witness, Your Lordships, has given a complaint. And Your Lordships, this affidavit has been filed by Superintendent of Police, Anti-Corruption, CBI, Your Lordships. Why would the CBI SP, Your Lordship, take risk of repeatedly stating everything is mentioned in case diary, Your Lordships?
So your submission is twofold. One is he is threefold rather. One is he is threatening the IO. Second is he is threatening the witnesses.
And third is
cases are registered. Annexure 5 you are referring to.
He is not
Third
cooperating.
He made a wrong statement before the court where the application for modification was moved by them. So these are the three precise submission you have.
No. Apart from that, also, Your Lordships, he is not cooperating in further investigation, which is a part of the case diary, and giving evasive answers. And Your Lordships, I don't want to mention, that is all mentioned in the case diary, how he is trying to, Your Lordships, play with the justice delivery system. He is saying that it will be better for me not to further investigate. And about him and his family members in 80 group matter, also he will drag me into trouble by making false allegations at different quarters, including the trial court and high court. Further, he also added that he will resort to any means to finish my career by exerting his personal influence and through media. So what is this? What kind of language is this? I'll finish your career. I'll manage the High Court. And the learned counsel for the opposite party is making a submission that both cost or bail milla. It was argued on merits, Your Lordships. He might have got at that point of time. What kind of submission is this? Just because he got a bail, it doesn't give him a license to tell that I will manage the High Court. I'll finish your career.
Remain in custody how much?
More than 2 years.
Yes, in the Melody, when you remember that CBI case,
Pradhanavu, the IO is here, your lordships.
also the witness was also the accused,
But see the manner in which you are.
not there to remember.
The total false, I will show from the record itself, my lord. Kindly see page number annexure 5. I will read how the false manipulation is this very part of this. Very the
Annexure 5.
Annexure 5, my lord. With humble request, I see such and such. While I was, kindly see the subject. Subject is no action. It means earlier some complaint was filed, which is not on record. This is the subsidiary when action was not being initiated. So for the bail, they should have filed at least original complaint so that the court can understand that what is the original complaint. This is no action. With humble request, I, Sri Sudhakar Shekhar Patnaik, while I was going towards Khandagiri on 1st of February 2021. After the 7 years of my bail, the case is of 2020 and 7 number of charges has been filed. And this Sudhakar Shekhar has been examined more than 20-25 times.
He is one of the witness.
One of the witness, he has been examined regularly. I have appeared before the CBI 130 times. Every first Monday of the month, I have to appear without any summons. And what modification done by the court is that now you need not to go or every Monday, but whenever you will call, you have to appear. What I have done, I move an application against this IO because IO was not behaving me properly. So I moved an application to the CBI directors, some maybe departmental inquiry.
Where is that application?
That's I'm requesting to put on record, my lord. There are many.
Show me if you have it.
I don't have it right now because ED has.
What was the allegation you made against the IO?
That he is calling me, not asking any question. In the morning, he asked me to sit there, and whole day I used to pass there without even a single query. And this is very exposed, my lord, in the charge sheet. One set of stanza is there that Mr. Vikas Swine has done this, and every supplementary challan has the same set of allegations, same question, same answer. Nothing new has come till date. So, my lord, can you imagine a person who is going asked every Monday and asked to sit from 10 to 5 with the IO not putting any question? So I am fed up. My wife was suffering from cancer. She was admitted in the AIMS hospital. She was operated, I whole 2 months, and I just requested the IO that kindly give me indulgence. My wife is passing through the life and death. Give me some time. He said, no, you have to come.
Mr. Pradhan,
Here, your lordships. Your lordships.
One
The learned Mr. Pradhan is online, your lordships.
Mr. Pradhan,
Sir.
Is there any complaint against you by this accused to the director of CBI? You answer yes or no?
No, sir.
You don't know, or
But,
it is, in fact, it's not there?
Sir, I don't know, sir. He had informed me that he has made some complaint against me to director CBI, but that's not in my knowledge.
How many times this accused has appeared before you? Exactly.
Sir, he was directed by Honorable High Court to appear before me on a first Monday of every month, sir.
No, how many time he has appeared before you?
Sir, he used to appear before me and sign the register and just leave.
Tell me how many times, sir?
Sir, I have to check, sir.
Roughly give an overall idea.
Whether it is 100 the submissions.
Not 130 times, sir.
You just give a overall idea how many times he has appeared.
Nearly 70 to 80 months he has appeared.
Okay.
On
70, let us consider the lower side, 70. An accused appearing before you 70 times is not enough to complete the investigation?
Sir, actually, he used to just give his appearance in compliance to the direction of Honorable High Court. I have never.
So the idea of direction is to see that the investigation is completed and he should cooperate to the investigation. A person is repeatedly called for 70 times he appears, you don't conclude.
No, he was not called, my lord. He was actually complying his bail condition.
After the modification, how many times you have called?
No, I have never called.
How much time you need? How many appearances you need to conclude the investigation?
Sir, actually, he is not cooperating, sir.
I'm asking. He will cooperate. We'll see that how he is not cooperating.
So Lordships, if you'll come and start threatening the IO, start threatening the judges, start
No,
threatening.
Mr. Naik, the problem is, I'll tell you, he says that he has given some complaint. How do you know whether this diary entries are made by vengeance or it is something? Why should you get into all these things? Let us see how much time he needs for investigation. And some condition we will modify it, and I'll ask him to appear before the IO as and when you required, and conclude the investigation.
Ask me a pertinent question.
2 years he has already undergone. And
Your
what are
Lordship,
the 420 charges? 420, 468, 471.
409 is also there, also life imprisonment. And apart from that, Your Lordship, under 114E of the Indian Evidence Act, Your Lordships, court may presume existence of certain facts that judicial and official acts have been regularly performed. These are official acts, Your Lordships. Therefore, Your Lordship, it has to be presumed that the IO has done his job properly. Unless contrary is proved by the accused, that will trial, Your Lordships. 114E of the Indian Evidence Act.
See, this is my suggestion, and if you want that it should be disposed upon merits, then I'll have to give one opportunity to them to place on record whatever he says. I'll fix it as per your convenience. You tell me when. Next week or 1 week thereafter?
Next week, Your Lordships. Next.
Friday.
Next.
I'm ready for both, whether on merit or you as my
Friday, I'll see if this is the case, then I'll get into the rules of it.
Yes.
I'm actually a normal person put it mind me.
By way of last and final opportunity, Mr. Bhupinder Singh has filed the Wakalatnama on behalf of the opposite party in place of Mr. Lalit Mishra. Same is taken on record. By way of last and final opportunity, the opposite party is granted 1 week time. No, 1 week time. 1 week time to file a response. In the meantime, Mr. Lalit Mishra, led counsel for the petitioner, submits that he would be and Bhupinder Singh, his client would be appearing before the IO for the to extend cooperation for the purpose of further investigation. And I want leave this week. Next week, Tuesday.
Let the time be fixed. I will be there.
You go. Yes, Mr. Pradhan. When do you want him?
Monday or whatever.
Next week, when do you want him?
On Monday, sir.
Monday.
All right.
Monday at 2 o'clock. Mr. Singh, the counsel appearing for the petitioner, submits that his client would be appearing before the IO on Monday at 2 p.m.
May I request for maybe 2 weeks?
No, 1 week. This is
So what is
the allegations are very serious, and I could have taken it lightly, but once you say that I'll manage High Court also, you can manage anyone.
Total false. I will show by response.
So whether it is false or not, I want to get into.
Please.
Also, what does it be by both?
What you have done. This
Total
is
false one. No, not required. Whatever my lord is saying.
This is not the job of advocate. Don't denigrate the office of it.
Also, what is the
Before IO. Don't do that.
Also, what is the exact date?
We are the lawyers are far above than this thing.
Great.
So don't even say that he'll accompany an accused to appear before IO.
Both are
it's not the job of lawyer.
Both are acquainted each other. They are facing each other from last 10 years.
Let them do whatever.
Whatever.
You people will not be a party to that.
Yes, sir.
You also, what is the exact date?
Decide on the mail. Okay.
So what is the date?
Friday. Not this Friday. Coming Friday.
What is the date, Your Lordship? 27th?
26th.
Your Lordship, can it be on 25th? Your Lordship, can it be on 25th, Thursday?
20.
Thursday.
In case I'm not able to come, may I get the opportunity to?
You can appear through. Yes. No problem.
In case, otherwise, I would like to come, but yes. In case.
All right, no problem.
Great.
Oblige, Your Lordships.
Avail this facility. Why not?
Oblige, Lordships.
And almost all the cases Mr. Naik is doing from there. Delhi.
I'm encouraged because of his performance.
It's very good. He's doing from there only all the matters he is attending.
All sensitive cases, sir.
He's doing no problem. Very effectively. We have a system. There is no hindrance.
Also, I have come up with 3, 4, 5 cases. But
He's doing from there, no problem. Yes.
Great.
Thank you. Yes. 38. Yes.
38.
Your
Lordship may remember, long past discharge order was passed. That is in the month of January.
Little this side, yes.
Discharge order passed long past in January 2011.
এটা আপনারা appear করছেন
Instruction ଅଛି instruction ଅଛି
appear করছেন কি কেস আমরা তো নোটিস insufficient বলে
By appearing, let him appear.
if he appears I'll be happy to
Yes.
but
You
last
have been
occasion-
discharged, according to you, you have been
Milord,
discharged
sir.
in 2009, and which is being challenged by them.
Milord sir, may I submit one thing?
Man of 73 years
One minute.
suffering from
No, 73, yes. The charge sheet indicates you are of, the filed in 2009, you are 58 years. Now I was calculating 73 years old now. Now, but last occasion, Dishonor Court directed to file fresh requisite. Requisites was filed earlier.
But he is appearing also.
Then his appearance may be recorded.
Appearance.
Because I was thinking that if nobody appears, then I was thinking
You are not prepared.
no, no problem, but it will take some time, because my entire endeavor will to satisfy that he in fact signed the agreements with Mr. A.K. Das on 24th September 97, showing the property free from all kind of litigations, which is not true.
Don't have brief also, sir.
Milord, don't have any scrap of paper because I have been instructed he is suffering from neurotic problems and treatment. And
But that's not a problem. If you want a copy, then I will arrange one. Or do you have that pen drive with you?
Appearance on behalf of
Get the copy.
opposite party. Our party, we request for a copy of the petition. Mr. Das undertakes to supply a copy of the petition. Reach the matter. And next week, anytime, next week?
Milord, next week I will not be available. I have to go to outside because of treatment of my wife.
Okay, no problem. No,
Month
keep
of
it. Keep it.
কেবে ଯିବେ?
August.
When do you want? You tell me.
Next month.
না next month না, ମୁଁ ସାରିଦେବି ମାନେ ଆবার ସାରିଦେଇ ଯିବେ ତ କେବେ ଯିବେ?
Wife ରହିବନି।
No, wait,
He has some personal problem. His wife is not.
19 ରେ ଯିବି।
When 19th? Then it's all right.
His wife is not well.
19th first.
Whenever you want, you tell, because you have a personal
August,
problem.
August 2nd week any day.
13th August. Yes.
13 August.
44.
I had supplied a copy of that judgment to my learned.
Yes, ready.
That's, in fact, my learned senior, Mr. Panda, supplied me. I'm provided with two judgments, my lords. Copy of the two judgments copies, my lords.
Yes.
Your lordship may go through that second case, my lords, that is criminal revision number. Judgment dated 25th 11th 2022, my lords. Passed in criminal revision 273 of 2019, my lords. But in fact, the issue, if lordship permit, the issue involved in one line is, my lords, that the petitioner.
Judgment, where is it? Where are the judgment? Huh? Must be there inside. Give me the file. Maybe there. At the end.
Not in judgment, my lord. Judgment, my Mr. Ponda supplied, my lord.
Yes.
It passed in another case.
This is
I think that is
That
flagged.
273 of 2019.
596. One is
Yeah,
No, the second case.
Criminal
Second case.
73 of 19, my lord.
Same petitioner. And coincidentally, I was there and Mr. Ponda was there.
273. It is there.
This is that judgment, my lords. My lord, so far the issue involved on the factual aspect, my lords, same, my lord, because the issue around one line, my lords, that petitioner says that he has no role so far selection of fake units for distribution of subsidized coal. Subsidized coals were distributed to different units, my lord. But in this case, well, the allegation was that it was he was responsible for selection of fake units for distribution of subsidized coals, my lords. He was the branch manager of that particular Odisha Consumer Cooperative Society Federation. But the same issue, same allegations, my lords, that in that case, the reported judgment dated 25/11/2022. That is covered, my lords. That's so far issue and factual has been covered. But my
Covered or
my
covered,
my
but-
se- my se- but no technical lords. My senior to reconcile the TR number, because in present case the TR number is 2016, and other two cases, that is 46, 47, TR number are different, that you will reconcile. So I don't say it's any anomalies that one has to reconcile, because while dictating order, that will be convenient to your lordship. And the PS case was also different, but the issue and the factual aspect is same.
This gentleman,
The same person, my lords, was there in the judgments.
same FIR?
FR date is different.
Different affair. But the allegation issue is the same.
Verbatim same.
I agree, my lord. So far, the issue, the factual aspect involved regarding the distribution of subsidized coals, my lords, to fake units, my lord. That was the allegations, my
So
lords.
you applied for discharge, which has been rejected, isn't it? Your application rejected.
And in one case, he has come up with some
Yes,
reports,
we have challenged the
and revision was allowed. So.
in 676 milliards, cognizance is challenged. In the two other cases,
These two
discharge petition has been.
Challenge cognizance. And the same gentleman is accused in two cases.
No,
Prabhakar
no,
Naik.
no,
He's accused of 4 cases. This is the judgment.
This is also Prabhakar.
Yes.
The other one is also Prabhakar.
May I suggest, my lord? So for the first case, the lordship is holding that 676-19, my lords. Let this particular judgment passed by Justice Sasikant Mishra, my lord, Honorable Justice Sasikant Mishra, my lords. I think the factual
covers the
issues
case.
covers, my lord,
Covers.
except the date of the affair.
Case
and
number, affair
yeah,
date, evidence change.
But so far, these 46, 47 cases,
This is done then.
I believe.
676 done.
But the lordship,
Let us come to the next.
the factor of similarity with regard to criminal legend 273 of 19, lords.
Second one.
No. The judgment, your lordship, that judgment my learned friend has submitted.
I have given.
I am not relying upon that. Forget it. Why should one judgment is enough?
That judgment is good.
The other judgment just
The other judgment, another
judgment I am
person.
ignoring.
Another judgment
Because
is
one judgment is enough to cover.
and the same person, no? Same. But so far, these 46, 47 concern, my lords.
46?
46 and 47. These are the cases, my lords. My lords. I found that.
He same Prabhakar Naik.
The same Prabhakar now, factual aspects, same, but in these two cases, my lord, I've not got any instruction, my lords. The first case they have filed, but issues are same, my lord. But about the averments taken out.
All 46, 47, everything disposed of. I'll record your
Strong objections.
Very strong objection in both the matter.
Vehement.
First matter only strong is.
No, your lordship may say vehemently object.
No,
Vehemently object.
I understand my predicament.
First matter only strong objection. And these matters very strong and very, very strong.
No, this is a fresh case that I have provided the copies, my lords, when not instruction, but issues are same, factual said. My predicament is that I can wriggle out the judgment in which I was arguing on the same issues, my lord, and all. The judgment is.
Why to keep pending so many matters?
No, in fact, we are coming up new numbers of old matters, my lordship. Today also finish.
Yes. Done.
I would have the 45.
46, 47 and
44, 46, 47. Cover. I would have the 40.
But antecedents has no bearing.
There are no
How many
antecedents.
cases you
There
have?
are no antecedents, my lord.
5 cases.
Yes. That has arisen, my lords. How? Because different affairs were lost with respect to different orders. That's
different areas.
Different areas.
One is Jajpur. Could you have kind
Jilla where you
For every area, one FIR.
That I wanted that this should be reconciled so that your lordship will be clear.
Next. Give it to me. Dispose of. 45.
Please, your lordship. In item 45, amendments have been effected.
So 45 and some other days. I'm sorry.
It's all right.
It's a Pandora box.
Give a date convenient to Mr.
We will have it in the first week of next month.
First week of next. sir is sitting and ask him which matter.
First week next month they will.
First week रे भी बहुत है भाई आपसे 29th वाला Let no
नहीं संग्राम बाबू
29th for the by week commencing from 22nd also a lot of cases.
Fifth, he's saying fifth.
But I have ready with my old cases list, my lord. That I'll be utilizing in this particular bench, my lords. Oh, very good.
In that there is an interim arrangement.
That interim arrangement will continue.
Oh.
My item is 52. So I pray if it can be taken up day after tomorrow.
The 2 p.m.
2 p.m. Day after tomorrow, 2 p.m.
Is there any very this I understand. This is no coercive. No
My
coercive.
arrangement is there. Day after tomorrow, this week, day after tomorrow.
What is this no coercive?
At least let it be treated as part of.
Yes, why day after tomorrow, but I'm not taking next week.
No, this is the problem. I'll tell you.
But let me start.
No. I'll tell you problem. Problem is supplementary, no? Supplementary. Problem is, because of this, he has to answer to the department.
No,
What action you have taken, you are not getting the matter heard. All these things. So that is why he says that parted at least he
parted.
Make a
Yes, parted.
It will appear as if he is made an attempt.
Yes. It has been hard and it is
a small matter.
very small matter.
That case.
He is in a case of acquittal.
For my learned friend, it's a very small matter. For me, it's a
small matter. All the witnesses, prosecution witnesses have corroborated each other. Commission has been made. Nobody has been declared hostile. So your lordship should know the judgment. At least your lordship will treat it.
Thank you so much, Mr.
Any
Kudian.
day your lordship will take.
Parted and put it
2 p.m.
2 p.m.
On Friday.
Friday.
Sir, 2 p.m. may not be possible because 2 p.m. I fix lot of matter.
Friday first case. My lord and friend says Friday.
Friday. Let it be on Friday. Let it be Friday. Not 2 p.m. Don't make 2 p.m. Supplementary. Parted. But written submission ready with you?
Citations are ready.
No, prepare a written submission and give.
I have prepared.
Ready. Weekly? Weekly continue?
No, weekly account.
How? I have to dictate the orders also.
Yes. So many.
Thank you. Thank you.
Grateful.